All right, our last presentation of the day is also our fourth student speaker, Crystal Rose. Crystal was born and raised here in Lubbock, where she attended college at Texas Tech University, graduating with a degree in sociology. Crystal's a third-year student currently with our journal. She is the executive comment editor, and she also currently works for the local law firm of Ware, Shea, and Garcia. Crystal will be presenting her article published in Volume 7, Book 1, titled Decanting Without Wine, The Trust Way. Please join me in welcoming Crystal Rose.
Thank you, and good afternoon. As Evan said, I will be talking about decanting and the recent decanting statute that Texas passed in the last legislative session. But first, what is decanting? Decanting is the process by which many people pour a bottle of wine into a decanter to stimulate the oxidation process and filter sediments, bringing life to an older bottle of wine. Likewise, decanting a trust allows a trustee to pour assets from one trust into another trust in order to breathe life into the original trust. This can be used to remove sediments such as tax problems or to make up for any recent changes in the law. Now, trust decanting has been recognized under common law since at least the 1940s. States have also recently begun enacting decanting statutes, and currently about 20 states, including Texas, have decanting statutes. The trust instrument itself may also be used as authority to decant into a second trust. The rationale behind decanting is similar to that of a special power of appointment. If a trustee has a discretionary power to distribute property to or for the benefit of a beneficiary, then that trustee has a special power of appointment, which will enable him or her to distribute property into a second trust for the benefit of the beneficiaries. Now, as I said, Texas does have a decanting statute that was passed in the last legislative session, and knowing the details about this Texas statute can benefit attorneys not only after the trust is in effect, but also when drafting the original trust. First question to ask is, when can a trustee decant? If the trustee has full discretion, this means that there is no ascertainable standard by which the trustee may distribute property. In this case, the trustee may decant some or all of the trust property into a second trust for the benefit of one or more current beneficiaries of the first trust. The trustee has the discretion to grant a power of appointment to a beneficiary of the first trust who is eligible to receive property outright under the terms of the first trust. This can be used to add beneficiaries by granting a power of appointment to a current beneficiary and then having that person exercise the power of appointment in favor of another person. If the trustee has limited discretion, this means that the trustee has some ascertainable standard by which they must distribute property. This can be as narrow as mandatory distributions by age or as broad as the health and welfare of a beneficiary. A trustee with limited discretion may decant some or all of the property into the second trust, but the beneficiaries of the first trust must remain the same beneficiaries in the second trust. If the beneficiaries of the first trust are a class of persons, then the beneficiaries of the second trust must include everyone who is or could be included in that class. The distributive provisions of the second trust must also remain the same as the first trust, and the trustee does not have the power to grant a power of appointment, but if there is a power of appointment in the first trust, it must remain the same in the second trust. Due to these limitations, it is likely that a trustee with limited discretion will only use decanting for administrative purposes, such as clarifying the law, providing for a fiduciary or a financial advisor to make investment decisions, or to provide for a successor trustee or co-trustee. Now, if a trust has two trustees, one with full discretion and one with limited discretion, then the trustee with full discretion may exercise his broader power to decant under the full discretion statute. Also, a trustee may exercise his power to decant regardless of whether there is an actual need to decant, but the trustee does not have the duty to review the trust instrument to decide whether decanting is in the best interest, so long as the trustee is acting in good faith. A trustee also does not have the duty to inform beneficiaries about the availability of decanting. When drafting the second trust, there are a few things that you need to know and keep in mind. The settlor of the first trust is considered the settlor of the second trust to the extent that the property from the second trust is that from the first trust. This is used when you're decanting one trust into another trust that's already existing, or when you're merging two trusts into a third trust. Also, a trustee must not reduce, limit, or modify the beneficiary's current vested right to receive a mandatory distribution under the first trust. As far as the trustee is concerned, a trustee may not limit the trustee's own fiduciary duties or decrease or indemnify the trustee from potential liability. The trustee may also not eliminate a provision that grants another person the ability to remove or replace the trustee. Last, the trustee cannot reduce, limit, or modify a perpetuities provision unless the first trust expressly permits it. So this lends itself to a drafting tip. If you're drafting a trust that will potentially last long enough for the perpetuities provision, you should think about putting in a provision that allows the language, the period, to be modified through decanting. A trustee may decant without obtaining consent from the settlor or from the beneficiaries, and without obtaining court approval, so long as the trustee gives notice to all reasonably ascertainable beneficiaries. This notice requirement may also be waived by the beneficiaries. The notice must be in writing and include a statement the trustee intends to exercise his power to decant, and that the beneficiaries may object or petition the court for approval or modification. The notice must also include the date of distribution, which must be at least 30 days from the date of notice, the trustee's name and address, and a copy of the first trust and proposed second trust. Notice must be given via registered mail or certified mail return receipt requested, or by personal delivery. If the trustee does not receive any written objections by the proposed date of proposal or distribution, the trustee may go ahead and decant the trust. However, if the trustee does receive a written objection, the statute only provides that the trustee may petition the court for approval, although I would recommend that you go ahead and inform your trustee to petition the court for approval. If, however, the trustee receives a written objection from the Attorney General's office, such as in the case of a charity, the trustee must petition the court for approval or modification of the decanting. Regardless of whether the court is petitioned by a trustee or by a beneficiary, the trustee must prove that the distribution will further the original purpose of the trust. And that wasn't on that slide. Sorry about that. That was that slide. Let me go back to this one. If the trustee distributes all of the property into a trust and come to find out that the property, that there's more property that belongs to the first trust, then that property will become property of the second trust. However, if the trustee only partially distributes property to the first trust, then any subsequently discovered assets that go to the first trust will remain property of the first trust. Sorry about that, guys. There are the notice requirements. And last, limitations. Trustee cannot arbitrarily decant a trust. While the statute doesn't oppose a duty to decant a trust, it also cannot be used to take away the trustee's fiduciary duties. Also, if the first trust expressly prohibits distribution, a trustee cannot decant regardless of the statute. This is another drafting technique. If your client does not want the trustee to have the power to distribute into a second trust, you should include a provision that expressly prohibits it. And last, a trustee cannot exercise the power to decant solely to change the terms of the agreement, or the terms of the compensation of the trustee. If the trustee decants for another valid, reasonable purpose, however, the trustee may go ahead and change the terms of compensation. Otherwise, the first trust terms will continue to apply in the second trust. Decanting a trust is one way in which you can modify an irrevocable trust. And although this was super fast and I don't have the time to go through all the details of the statute, I would highly recommend that you know and understand the terms of the decanting statute in Texas. Thank you. What?
Thank you so much, Crystal. Well, that brings us to the end of our presentations today. We really appreciate everyone involving us in the West Texas legal community, and for all of you no matter how difficult your journeys were, for making the effort to be here with us. There is a dessert reception. There's cookies and cupcakes out in the Lanier Auditorium just outside it, or in the Lanier Atrium just outside the doors. And we really do hope that you'll all be able to join us again next year. Thank you so much.